Well, with that prior conversation about the importance of lawyers in Laura's life, we are now going to turn to supporting foster youth in dependency court. And we're going to start with Andrew Kane, talking about the overview of the dependency court, talking about that system, and then Karina and Roger on support issues related to the court function. So, Andrew?
Good afternoon, Mr. Chair. Thank you for having me. And now that I know there's a youth in the audience who wants to be a foster youth lawyer, I'll try to be on my A game as a foster youth lawyer. My name is Andrew Kane. I am a supervising attorney with Legal Advocates for Children and Youth in San Jose. Our office represents approximately 90% of the juvenile dependents in Santa Clara County. We've been doing that for approximately 6 years now. I oversee a unit of 12 attorneys who are in court every day advocating on behalf of foster youth. One of the things that I thought about in preparation for my remarks today is that I think as an entire system, and I'm using the term system broadly to talk about the legislature, the executive, the judiciary, all of the stakeholders and advocates, we have a really loud voice on behalf of youth in the child welfare system, that portion of foster youth. But sometimes there are players in the system that forget that there's this other population of foster youth in the juvenile justice system, and then there's the entire at-risk youth population in the juvenile justice system. And that population, given that they are also at risk, given that the vast majority of them have suffered abuse, neglect, or some other type of trauma, they are an incredibly important population for us to be mindful about and to talk about the best ways that we can serve them and advocate for them. So I thank you, Mr. Chair, for giving us the opportunity today to provide an overview of that system and particularly how it intersects with the juvenile dependency system. Okay. I was reading a report last night and I came across a quote that struck me. It said, almost all youth participate in some form of delinquent behavior. The example they gave was underage alcohol consumption. But few have contact with the juvenile justice system. Those that do have increased risk factors for substance use and dependency, school dropout, early pregnancy, and development of psychiatric disorders. Those are just a small number of the reasons why it's important to talk about this population. The juvenile court system as a whole, it has a broad purpose, and that purpose is to provide protection both for children but also for the public. The juvenile dependency and delinquency systems have differing purposes to some extent. The juvenile dependency system is where you find the goal of providing maximum protection for youth who have been abused or neglected as the primary goal that we're working towards. The juvenile delinquency system, we are also looking towards protection of the youth, but we also have to look at accountability factors and protection of the public as well. Now, as I alluded to earlier, and as Mr. Chair, I'm sure you know, there is a significant intersection between the juvenile justice system and the juvenile dependency system. At any given time, we have thousands of youth across California who are having simultaneous involvement with the system that we know of, that are at one time working in both systems, and we have in each system at any given time a number of youth who can probably touch both systems. How a youth gets into the juvenile justice system is through a filing by probation. And the vast majority of referrals to probation, I think the numbers show it's about 90%, are coming from law enforcement. So a youth has a contact with a law enforcement official and then refers that youth to probation, and probation decides what to do next, whether it's a filing in court, whether it's to dismiss with some lower level citation, or whether it's to informally work with the youth on probation without bringing it before court. If a youth comes before the court system and that youth already has juvenile dependency involvement, the law says that there needs to be a decision about which system best serves that youth. That's Welfare and Institutions Code section 241.1. Until 2005, what that law said is that a youth could not simultaneously be involved in both systems. If you had a dependent...
That was until when?
2005. Yeah. If you had a dependent who came to the attention of the juvenile justice court, you would have to decide whether the youth should stay in dependency or go to juvenile justice. Vice versa, if you had a youth in juvenile justice court and there were family issues that came to the attention of the court that might better be served in dependency, you had to decide whether to keep that case in juvenile justice or send it over to dependency. The legislation that was enacted that took effect in 2005, which was Assembly Bill 129, created this system of what we call dual status, whereby a youth could simultaneously be a dependent and a ward of the court. Now, how that system works is, first, a county has to create a protocol between its child welfare agency, its probation, and its courts in order to say that a youth could be adjudged as dual status. Currently, we have 15 counties in this state who have adopted protocols, my county being one of those.
Are they major urban counties?
There's a mix. The bigger counties, from what I was able to determine, are Santa Clara, Los Angeles, Riverside, San Bernardino, I think San Mateo. There may be one or two other bigger counties, and then the rest are some of the smaller counties as well. And to be clear, I don't have the exhaustive list, so I might have been missing one or two of the
conversation.
Right. Just wanted to be clear on that point.
Yeah.
So counties that have adopted this protocol, essentially what they're saying is that we may still decide that a youth should be served by only one system, either dependency or delinquency, if they have some sort of crossover, but we are going to have the option to allow this youth to be served simultaneously by both systems. How that decision is made is, once it's come to the attention of the court or to child welfare or probation that there is a youth that may have issues within both systems, there needs to be a decision made between child welfare and probation as to which system each side thinks is better to serve the youth, child welfare, delinquency, or child welfare, probation, or both simultaneously. Recommendations are made to a judge, and then the judge decides. And the judge is deciding, should this youth be a delinquent or a ward of the court under Welfare and Institutions Code 602, dependent under 300, or dual status. I will say that from my perspective, which is, again, from a county where we've adopted one of these protocols, the transition has been mostly good to working with this. We have recently moved towards creating a co-located unit of probation officers and social workers who are working together on behalf of youth to help determine which system is better for that youth, when both systems are working together, how to best promote collaboration between the two sides, to have efficient use of resources, not duplicate things. And we're still kind of in the...
So those people sort of have are developing a common framework. They work through these kinds of issues regularly, so they sort of know how they break it down. And
they do. And I will say that there are, when I said that it's mostly smooth, there are some bumps in the road. One of the issues that I was just talking to Roger about before we took the podium is that both sides have concerns about net widening. The idea that some youth who shouldn't be in one system will get trapped in another, specifically youth who shouldn't be in probation will get trapped over there and not be in child welfare. That's something we are continually discussing at stakeholder meetings that we have very frequently.
But you refer to that as net widening?
I think in the advocacy community,
it's your net and
yes,
they get dragged in.
Yes, exactly. If a youth ends up in the juvenile justice system where probation is going to be taking the lead and providing that youth services, it's important to know, I think, what kind of placements are available for those youth. We break them down into sort of two large categories: secure placements and non-secure placements. The non-secure placements are basically the same options that you would find in juvenile dependency: relatives, foster homes, group homes. The secure placements are juvenile hall, ranches or camps that are operated by the counties, and then in the most extreme cases, the Division of Juvenile Justice underneath the Department of Corrections umbrella. The good news on that front is statewide, we have seen a very significant decrease over the last 10 years in the use of DJJ as a placement for youth. The statistics, I believe, Roger can correct me if I'm wrong, are currently a little under 700 youth are in state custody under DJJ, and that's almost a 300% to 400% drop in the last 10 years. So I think that's a testament to a lot of the good work that's going on. But there's still more work to be done. And I think one of the primary areas where we need to continue hammering the point home is that youth who are in the juvenile justice system, regardless of whether they have come from juvenile dependency, but particularly if they have, are themselves victims of abuse, neglect, or some other kind of trauma. And we need to still continue to push that major culture shift, particularly within probation departments, to recognize that very important fact, because that colors every single thing we do with that youth and the importance of providing services to address that trauma. The other thing that we need to continue doing, and this is where I'm going to segue over to Karina and Roger, is to make sure that the council who are working with these youth, the people involved in these cases who are the true only voice that are advocating for the youth and the youth only, have the proper resources to be able to do their job. That's important in both systems, but it's incredibly important when you have a youth who is touching on both systems, because these are daunting systems. Let's face it. I mean, you heard from relative caregivers earlier who are struggling with the system because it's so complex and so daunting. Imagine a youth who has been the victim of abuse, neglect, or some other kind of trauma trying to navigate one of these systems, let alone both. And so we as attorneys can help them navigate that system and provide the critical voice that they need. But I will tell you that I could speak for a while about that, but you're not going to hear a better voice for that subject than a foster youth themselves. And I've had the pleasure of hearing Karina speak. She testified, I think it was last month, before the Senate Budget Subcommittee that was dealing with the Dependency Council funding issue, and she was incredibly eloquent, and I'm very happy that she's here today to be able to share her story with you. Thank you.
Very
good. Good afternoon. My name is Karina, and I'm 19 years old, and I currently work as a customer service representative for an insurance agency. I wanted to share part of my story as to why and how I ended up in foster care. Each time I tell this story, I never quite know where to begin. However, today I will begin from the time that I was sexually abused by my mother's ex-boyfriend. It was a really hard and traumatizing experience. I was about 9 years old when the first incident happened, and then about 12 when the really bad phase started. I felt like I had no one to turn to. My mother wasn't an option since the first time that I told her, she didn't believe me. Long story short, I tried to commit suicide over the guilt that I felt. At the time, it seemed to me as if I was the one responsible for what had happened to me. Of course, now I know it wasn't. My mom notified her counselor from Birth and Beyond that I had tried to commit suicide, and of course her counselor followed protocol and called CPS. That's when my case first opened.
How old were you then?
I was 15. No, I was 14. I was 14. CPS tried to keep me with my mom, but one day she really got angry and hit me with the phone charger and left a scar on my body. And the next day, a social worker moved me and my 1-year-old sister to the children's home. In the beginning, I think that all new foster kids are really scared. I was 15 at the time. I was confused. I was scared. I can't imagine how a 5 or 6-year-old would react. Luckily, I was placed in the same foster home with my sister, and lucky for us, we got a really nice foster mom. Sadly, though, the first lawyer I had in my case didn't really hear me out. I think he had too much on his hands to actually spend time with me and pay attention to all of my needs, including my sister's needs. Then I met Regina.
So you were sort of advocating for yourself and also your...
Sort of. He actually made like an error because he confused my mother's boyfriend at the time for her ex-boyfriend. So he put a restriction order on the wrong person. But then I met Regina, my lawyer from CLC, Children's Law Center, and I swear she was like an angel. I feel so comfortable talking to her, and somehow she always made time to meet with me. She got to hear my whole side of the story and how I really felt about going back with my mom. Thanks to her, my little sister got to go back home soon after she got our case, and Regina got things going for my immigration case because I was an illegal immigrant as well. She even got in contact with immigration attorneys to represent me. She signed us up with the MQ counseling service, which was really helpful too. Since Regina didn't always have time to meet with me, EMQ was with me at least 3 times a week. During the time that I was in foster care, I moved schools a lot, and Regina made sure I was getting my credits. She was my go-to person for everything. It helped to know that no matter what, she was on my side. Whatever I needed, even if I just needed to talk, she would figure out a way to make time for me. I really thank her for all the time she spent on my case. I know that many things wouldn't have been possible if she had not been right there by me. I just cannot see how a child without an attorney could get through the whole foster care system. There are too many needs that a child has, and many times we don't know who to call. When I had those moments, Regina was my person to call. My hope today is to let you see why my attorney was so important to me and my sister in my case. It would have been helpful if maybe she would have had more time for us. I know that because of the lack of time, my immigration process took longer, and also my preparation to exit the foster care system when I was ready. Thankfully, it all worked out, and again, I thank Regina and CLC for all of the dedication to their clients. Thank you for your time.
Very good. Very good. Thank you very much for that statement. And you are from where?
I am from Mexico City,
Well, I meant
but
And that's fine.
in the Sacramento County.
here in Sacramento County.
Yeah.
Okay, very good. Thank you. Roger?
Good afternoon, Mr. Chairman. My name is Roger Chan. I am the Executive Director of East Bay Children's Law Offices in Alameda County. And thank you very much for inviting me to talk about the role of the Child's Attorney in Dependency Court. I think I will be able to try to tie everything that you heard today together, and I also have the chance to talk about what I think is one of the greatest jobs in the world. So today we have already heard about two very important rights of foster youth. The first is their right to be placed with a relative whenever possible, and their education and school stability rights. And we also heard about the challenges that are involved when protecting these rights. The child's dependency attorney is the person who can help find the relatives so that foster youth can be placed with them. Because the relative caregiver is not represented by counsel or a party to the dependency proceeding, the child's attorney is the one the relative can call, and the child's attorney can follow up on those funding rates to make sure that the relative is getting the proper financial support. The child's attorney is the one who can enforce school stability rights, who can ensure that schools the right to attend the school of origin is being enforced, and help make sure that youth are being connected to the appropriate services at their schools. These are just two of the many rights that foster youth have in California. I brought with me today a publication by the state foster care ombudsperson that outlines many more of the very basic fundamental rights that foster youth in California have. And I counted them. There's at least 35 just on this page, many of which we take for granted in our daily lives, but we can't assume, they can't be assumed for foster youth. And for example, I'll just start with the very first one, that a foster youth has a right to live in a safe and comfortable home. That's a very fundamental basic right that a child's attorney can ensure is being met on behalf of a child. California has provided foster youth with these many rights and protections, but these rights are only made meaningful if the foster youth has access to a qualified and competent attorney. I would like to take just a moment to tell you who are the children in foster care. They range from newborn babies up to age 21. They are disproportionately children of color, 23% African American, 49% Latino, 24% white. They come primarily from families living in poverty. Often the families have multi-generational cycles of abuse and neglect. And believe it or not, foster children did not have a right to counsel until 2001. Being a child's dependency attorney is unlike any other practice of law. Our job is to defend the rights of children, which requires us to both investigate and advocate outside the courtroom. I have represented youth myself for more than 15 years. I have had caseloads ranging from 75 to over 300. As you would expect of a lawyer, I've been in trial, I've been in mediations, I've filed legal motions. But as a child's lawyer, I've also visited youth in their homes. I've met their caregivers, I've shot hoops with them, I've had tea parties with little girls, all to make them comfortable so that they can talk to me about their case. I've attended IEP meetings to make sure that they have access to the appropriate educational supports in school. I've represented youth in their school discipline hearings. Sometimes I was the only adult who showed up on their behalf. I've negotiated 7-day placement termination notices so that youth would not have to move. As Andrew talked about with the dual status youth, I've advocated for foster youth not to be criminalized due to adolescent behavior or trauma-related behavior or mental health issues. And just as an aside, there are a number of different what we call specialty courts in the juvenile court that focus on, for example, substance abuse or girls' issues or dual status youth. These are special dedicated dockets where the judge is focusing on youth with particular problems that is outside of the main part of the dependency case that we as children's attorneys are a key part of. I've convinced my clients not to run away from their homes when they're having bad days, and when they are runaway status, I've convinced them to come back. I've picked some of them up. I've taken them to the assessment center so they can get a new placement. I've gone shopping for clothes with them and school supplies. As Karina mentioned, a very important role of the child's attorney is to identify outside needs or rights of the youth that need to be protected, like immigration rights. I've helped to both obtain special immigrant juvenile status for foster youth, as well as connecting them to an immigration attorney who can help them get legal permanent residency. We also need to identify youth who may have civil claims. I've helped youth get personal injury lawyers when they have been involved in car accidents. Youth who have inheritance from deceased parents need probate attorneys to protect their inheritance, and I've been involved in connecting them to the appropriate referral for that. In one case that I'll never forget, I represented an infant with multiple sclerosis. The Child Welfare Agency decided that this baby was not likely to be adopted, which meant that he was going to probably spend the rest of his life in foster care and some other kind of care. I found a private adoption agency that specialized in finding adoptive families for children with special needs, and they found a family for him, and he was indeed adopted. I've talked to doctors and therapists about my clients' treatment and their progress. I've asked questions about the benefits as well as the risks of psychotropic medications. I've helped my clients work out their problems when they were having difficulty with their county social workers. I've made sure that siblings were in contact with each other. And for me, I think most importantly, I've been available to listen to the hopes and dreams of my clients and then help them to find a plan to be on the right pathway. As Ms. Irwin, I think, mentioned earlier, part of it is about changing trajectories, and the child's attorney can be a key part of that. And you may be thinking that these are all things that a parent ought to be doing, but the truth of it is that for a foster youth, sometimes they can only turn to their lawyer for this kind of help. The Judicial Council regularly conducts a survey of how the lawyers in my office spend their time. My lawyers are in court at least 3.5 days a week, but according to the time study, they actually spend 70% of their time outside of court, meeting with clients, conducting investigations, and dealing with a myriad other issues that may arise. If you do the math, no one's working 40 hours a week. Every year, we travel tens of thousands of miles to visit our clients in their homes, wherever they may be placed. I think in Alameda County, more than 40% of our foster youth are placed outside of Alameda County, so we go out we travel out to see them. A typical day for a child's attorney, if they have court begins at 9. They'll spend the entire morning reviewing active cases in their various statuses. They'll take a short break for lunch. At 1:30, they'll return to court for the new cases that are coming in, and they'll meet clients for the first time and deal with the initial and detention hearings. They may make it back to the office if they're lucky by 4 o'clock, when they'll do phone calls, they'll check their voicemail, read the reports for the next day, and do further investigation. Or they may go out after court and go visit clients in their home. On the rare day when they have no court, they spend their time visiting clients in their homes, attending school meetings, team decision-making meetings, doing trial prep, or participating in training programs. So what is the number one challenge for providing or protecting the right to counsel for foster youth? The ability to adequately protect a child's right to counsel is currently threatened, quite simply, by inadequate state funding. Excessive caseloads are the primary indication that effective counsel is not being provided to children. In some counties, caseloads range from 300, such as Los Angeles, and to 500, such as in Ventura, 500 clients per attorney. These prohibitively high caseloads mean that foster youth cannot get their cases investigated, and probably can't even get a phone call return just simply for lack of time. The lawyer is forced to choose between competing clients' needs and having to choose whichever crisis is the most urgent in that moment. And they're all
tyranny
crises.
of the urgent. There's like
Exactly.
important things, and you deal with what's urgent.
And that's the triage approach that we all know is true in the dependency court system. This is no way to provide foster youth with the right to counsel. I believe that the state has a moral and legal obligation to ensure that all foster youth have a meaningful right to counsel by providing sufficient funding for trained and competent attorneys with manageable caseloads. Finally, I would like to bring to your attention a report that was issued just today by the ACLU titled System on the Brink. This report concluded that California is violating the constitutional rights of children and parents in dependency court by not providing sufficient funding to ensure competent legal representation. There has been no increase in statewide funding for dependency counsel since 2009. The current budget is underfunded by at least $33.1 million, and that would just get us to what the 2009 standard was. We are at a point of constitutional crisis for foster youth and their parents. So what must we do? First and foremost, the state must fully fund court-appointed dependency counsel. Second, that funding must be used to recruit talented and passionate attorneys for youth and parents. Third, we must train these attorneys so that they are not just competent, but that they're excellent, and that they understand a specialized area of this practice. And finally, we need to retain lawyers. The role of the child's attorney has only expanded over the years, as the state has afforded additional protections ranging from school stability rights to protections against inappropriate prescription of psychotropic medications. With AB 12, extended foster care, the representation of a foster youth can last for years, up to age 21. Retention, that attorney-client relationship that Karina and others spoke about, that is critically important. And without the funding to retain qualified and competent attorneys, we are denying our children access to competent representation. Effective legal representation for foster youth is important to protecting their numerous rights, increasing permanency, promoting justice and access to the courts, and improving the overall well-being of our state's most vulnerable children. Thank you very much for your time.
Roger. I know this report is citing Judicial Council of California. So in their annual reports, do they keep a metric on dependency counsel? Was that a special study? I mean, to kind of focus on this issue of workload and caseload, is there some place that you can turn to kind of check in on what's the current caseload? Or was that
There's two studies that address caseload standards. One was by the ABA, which I believe recommended a caseload of 77 clients per attorney. In 2008, the Judicial Council did a dependency caseload standards, which I can leave with you if you like. And frankly, as a matter of they acknowledge as a matter of economic efficiencies that the state standard would be 188 clients per attorney if the attorney has help with a social work investigator.
Yeah. And do you know? And in the Judicial Council, they do an annual report. They boil out, distill down a lot of data on how our court systems operate. Do you know if the Dependency Council numbers are a part of the annual report, or is this sort of like a special data call or analysis? And if you don't know the answer, I'm just curious.
I don't know if
I've worked with the annual reports, and I'm just not familiar with the dependency issue. And your issue raises this question of, is there some way we can structure something to measure this so then you can really realize what's going on?
Yes. So I don't know if the dependency caseloads are specifically addressed in the Judicial Council annual report, but I can tell you that it's my understanding that the Judicial Council only has data for the counties that participate in what's called the draft program, and that they may not have the data from the other counties. There is currently a budget proposal that has been approved in both houses that would create a separate line item in the state budget for court-appointed dependency counsel as a mechanism to maybe gather better data on this.
Okay. All right.